In this video, we would like to discuss the development of public interest litigation in Indian perspective. Perhaps the concept of public interest litigation or social action litigation, without giving it a nomenclature, was initiated by Justice Krishnan Iyer in 1978 in Mumbai Kamgar Sabha case in 1978, wherein rule of standing were liberalized. This movement had the blessings of Supreme Court, High Courts, and finally from the then Chief Justice of India, Justice P.N. Bhagavati. The Supreme Court and High Courts treated letters from citizens as writ and tried to give speedy justice. The heart of the proceeding, in the words of Professor Upendra Baxi, that gross violation of fundamental rights that has been actually occurred in the exercise of state powers, either by commission, repression, or omission, lawless, disregard of statutory or constitutionally imposed duties. The petitioner is himself often not the victim of repression or lawlessness, but a public citizen. Further, he categorized and summed up in the following that at present, women under trial as well as convicted prisoners and those women in protective custody, children in juvenile institutions, bonded and migrant laborers, unorganized laborers, untouchables, landless agricultural laborers, victim of trafficking, slum dwellers, and pavement dwellers, and many more groups now flock to the Supreme Court seeking justice. And now we'll discuss those guidelines were developed by Supreme Court regarding public interest litigation, and those guidelines are bonded laborers matters and neglected children, non-payment of minimum wages, exploitation of casual worker, and violation of labor laws, petitions from jails on harassment, premature release and speedy trial, petitions against police for refusing to register a case, harassment and death in police custody, petitions on atrocities on women, harassment of bride, burning, rape, murder, kidnapping, etc. So also harassment and torture of scheduled caste, scheduled tribe and economically backward classes. So also environmental pollution, disturbances of ecological balance, drugs, food adulteration, maintenance of heritage and culture, antiques, forest and wildlife. So also petitions from riot victims and other matters of public importance. So PIL nowadays is in fact being applied for the enforcement of public duties enjoined by law towards the amelioration of downtrodden to enforce environmental laws, and those people, helpless victims, pavement dwellers, pollution of air, water, and government indifference attitude towards citizens' right to live with dignity. So also compensatory jurisprudence has also gained ground through public interest litigation. Therefore, the judiciary has taken upon itself the challenge to provide an opportunity to all to make their basic human rights more meaningful and to assure them social and economic justice. So, in our next video, we would like to discuss the very role of judiciary in connection to public interest litigations.